Good afternoon, everyone. Welcome to the 85th installment of the David C. Baum Memorial Lecture Series on Civil Liberties and Civil Rights here at the University of Illinois College of Law. Endowed in 1973 by the family and friends of David Baum, in his memory and at his request, this lecture series has served as a testament to the life and work of Professor Baum, who was a Harvard Law School and Harvard College graduate and a member of this faculty after having clerked for the Illinois Supreme Court from 1963 until his death a decade later. Throughout its history, this lecture series has hosted legal luminaries who have spoken on many of the most important issues of the day, and is a fitting memorial to a man known for his unrelenting intellectual vigor and unyielding moral integrity. It's a bit dangerous to offer a partial list of Baum lecturers, since every one of them really is worthy of inclusion. But names like Ruth Bader Ginsburg, Kathleen Sullivan, Akhil Amar, Larry Lessig, Cass Sunstein, and Derek Bell give you a sense of the towering figures who have graced this law school with their insights in this lecture series over the past 4+ decades. Today's lecture is certainly a giant in her fields, completely in keeping with the extremely high bar set by past lecturers. Indeed, she was one of those past lecturers in 2002, and as far as I can tell, and I always say that because I'm a lawyer, she's the only person to have delivered, or will be the only person to have delivered, 2 Baum lectures, and indeed the only person to have delivered 2 endowed lectures here in the College of Law. To me, that's quite telling of her high stature, but her worthiness of that distinction is really only one and not the most important reason I'm so happy that she's with us here today. I've known Pam for almost a quarter century now, and I knew of her even before our paths actually crossed in person. She attended Yale College and Yale Law School alongside my older brother, the aforementioned Akhil Amar, about a half-decade ahead of me, and I actually remember him telling me about Pam when I was getting ready to decide which law school to attend. And I was asking him, why should I choose Yale over these other schools? And he trotted Pam out as the kind of person that I would get to interact with if I chose to be in New Haven.
And you went anyway.
And I went anyway. And when I clerked for Justice Blackmun a few years after graduation, I was also quickly made aware of the big shoes that Pam left to fill there when she worked for him 5 years earlier. Justice Blackmun has had a lot of amazing clerks. If you look at Wikipedia, I mean, there's a lot of people there that I'm just kind of blown away to be in the company with. But I actually think Pam was one of the justice's absolute favorites. I remember in my interview, the justice and his staff asked me if I knew Pam, and I can't remember what I said, but I do have the feeling that if I had said the wrong thing at that moment, I would not have gotten the job. Pam's career since then has been meteoric, among other things. She was a professor at the University of Virginia School of Law, which I was reminded this morning have the same questionable blue and orange color scheme that we have. And then she moved west to Stanford, where she holds the Kenneth and Harle Montgomery Professorship of Public Interest Law, and where she also serves as the co-director and I think maybe co-founder of the Stanford Supreme Court Litigation Clinic, which has enabled her to work in recent years on a lot of briefing and argument of Supreme Court cases. She was appointed by President Obama in 2013 to serve as a Deputy Assistant AG in the Civil Rights Division of the Department of Justice. She received a number of honors there. She returned to Stanford this fall to resume her lifelong work as a leading scholar on voting rights, the political process, and the Constitution, including marriage equality and racial equality, which are themes for her talk today. She's a member of the American Academy of Arts and Sciences, which is a big deal if you don't know that, the American Academy of Appellate Lawyers, and the ALI, the American Law Institute, and has received far too many other high honors and accolades to enumerate. Since the 1990s, I've had the pleasure of working regularly alongside Pam in many endeavors, including the presentation of constitutional developments and Supreme Court cases at various federal judicial conferences in California and around the country. And there's a lot I could tell you about why we are so fortunate to have her with us today. This is something I don't say about all the people I'm fortunate enough to work with, but I invariably learn from Pam whenever I hear her. She is quite brilliant, and I'm always entertained by her. She is extraordinarily funny. But her deep insight and her exquisite wit are, if this is possible, exceeded by her immense passion and limitless compassion. And truth be told, those are the qualities I admire most in this most extraordinary person. So please join me in welcoming Pam to give the lecture today.
Well, it's a pleasure to be back here. It's also a pleasure. This is my first academic talk since leaving the Department of Justice, so I get to say what I really think again. And that's really a delight. I want to make sure I've got this in the right order here. Okay, great. So equal justice under law. Oh, good, it did come up. These inspiring words are inscribed on the architrave above the 16 marble capitals at the front entrance to the Supreme Court. I spent a lot of time looking at and thinking about those words last April when I went to hear the court's oral arguments in the marriage equality cases. I spent a lot of time thinking about these words. There are two tall flagpoles in front of the Supreme Court on the plaza, and I saw these words, equal justice under law, and the Star-Spangled Banner, both at the twilight's last gleaming and in the dawn's early light. Oral argument in the marriage cases was set for Tuesday, April 28th at 10 a.m. I arrived at the Supreme Court on Monday, April 27th at 2 p.m. to see the arguments. I sat or stood in line for roughly 20 hours to get a seat in the bar section of the Supreme Court. In one of those wonderful fortuities that really only happens in Washington, the man directly in front of me was Gary O'Connor, who's an assistant attorney general for the state of Maryland. I'd met him only once before, and that was in the bar line for the oral argument in Lawrence against Texas, the case in which the Supreme Court struck down Texas's ban on homosexual sexuality. That time, for Lawrence against Texas, I'd arrived at the Supreme Court at 5 a.m. in the morning of the oral argument to find myself the second person in the bar line, which is kind of like a nerd alert sign of something. This time, by contrast, we were almost a full day earlier, and there were dozens of people ahead of us in the line. Most of the people ahead of us at 2 p.m. when I got there, and an even greater share of the people actually sitting there at 2 a.m. were not, however, lawyers eager to see the arguments. They were paid line standers, hired by firms like linestanding.com, and billed out to clients at upwards of $50 an hour to hold places in the line. This is the bar line at the Supreme Court at 2 p.m. 2 years earlier, as one of the lawyers representing Edie Windsor in the challenge to the Federal Defense of Marriage Act, I'd been the beneficiary of a paid line stander. I actually got to sit at counsel table for the Windsor argument, but the day before was the argument in the Perry case from California. And our team thought it would be important that I see the arguments in Perry so that I could help my co-counsel, Robbie Kaplan, prepare for our own oral argument the next day. We thought that just listening to the audio tapes wouldn't be a full substitute for being in the courtroom to see the justices' reactions and their body language. And because Perry was such a hot ticket, the court had offered us only one seat in the bar section to prepare for Windsor the next day. So Paul Weiss hired a line stander for me. I hadn't given much thought to the decision, but when I arrived at the court at 5 a.m. to claim my spot, we had been told to be there before 7 when the Supreme Court police came on duty for their morning shift and they would direct anyone who wasn't a lawyer to leave the line. I was stunned, and I was ashamed. I had assumed the line standers were going to be college kids in parkas making a little bit of extra money. Instead, the line seemed to be composed entirely of middle-aged people of color, fast asleep on the ground under plastic sheets, under bundles of clothing, and under old movers' blankets. They'd apparently been recruited from nearby shelters to brave the 30-degree temperature with whatever belongings they had. We stood there for 2 hours, watching a line of homeless black men and women morph into a line of affluent white lawyers. I vowed then that I would never again pay a line stander to see an oral argument. Which explains why, 2 years later, I came on Monday equipped with 2 space blankets, mittens, Ibex long underwear, a rain poncho, a folding camp chair, an umbrella, an iPad, a cell phone, and a Kindle loaded with my special hours-long track of inspiring music. I sat down next to Gary, and I waited. That's why I look so bloated there. I'm actually wearing a lot of stuff under my suit. As the evening wore on, volunteers dropped off water and cookies. This is a little boy, his mom came and they were giving out Oreos and he was wearing a little Superman costume. Various friends stopped by to deliver hot meals and hand warmers. At around 11 p.m., some of the line standers asked Gary and me and Rick Rohn, one of the few other lawyers who was then still standing in line, whether we would hold their places while they went back to their shelter to freshen up. So for several hours in the darkest, coldest part of the night, we sat there keeping an eye on their empty chairs. I later heard that although they'd been promised $10 an hour for their 24 to 48-hour stints standing in line, some of the companies told them midway through their days on the line that they'd receive only half of that immediately and would have to come back 2 weeks later to get the rest of their pay. While I was sitting in line, both Monday afternoon and Tuesday morning, I spoke to a number of court officials who came out to take in the scene. They seemed genuinely surprised and taken aback. There were also several press reports about the paid line standers, nearly all of them critical. On first Monday this year, the Supreme Court's Public Information Office sent an email to the Supreme Court Press Corps noting some new procedures. The changes that received the most attention involved the court's decision to highlight any post-release edits to its opinion. Sometimes it gets things wrong and then it changes them, and you didn't know that they'd changed them. Well, now they will highlight those on their website, and they'll also deal with the problem of link rot that they were having, where the Supreme Court would cite web links and those links would disappear. And so they have a procedure for dealing with that as well. But at the end of this little press advisory came this sentence: beginning in October term 2015, only bar members who actually intend to attend oral argument will be allowed in line for the bar section. Line standers will not be permitted. I actually consider this one of my major victories at the Supreme Court in recent years. So in my talk today, I want to discuss 2 issues. The first is the Supreme Court's decision to change the rules for the bar line. Because how to run the bar line is a great illustration of a more general question that's occupied lawyers and political philosophers for years: the choice among markets, queues, and other methods for allocating scarce opportunities. The second thing I want to talk about, though, involves a particular irony of the bar line in which I stood. By 7 a.m., it was a line of lawyers come to see a milestone in the struggle for LGBT equality. But in the night, it had been a line of homeless people of color for whom the promises of equality made over a century before had not yet been realized. That cold morning was, in short, as Charles Dickens wrote long ago, both the season of light and the season of darkness. It was the spring of hope. It was the winter of despair. For supporters of social equality for LGBT persons, it was a spring of hope and a season of light. A moment in a struggle that had made stunning advances since the turn of the century. Lawrence against Texas, the repeal of Don't Ask, Don't Tell, a president who joined Stonewall to Seneca Falls and Selma in his litany of guiding stars of our journey for American equality, United States against Windsor. Within days after the court's decision in Obergefell, local officials across the nation began issuing marriage licenses to gay and lesbian couples. Last year, the Attorney General of the United States announced a change in the government's interpretation of Title VII. It now covers discrimination on the basis of gender identity. To be sure, there's been a lot of resistance of various kinds. Kim Davis, some of the state RFRAs, the recent defeat of Houston's Equal Rights Ordinance. But the direction and velocity of the change since the Supreme Court termed the claim that gay people were constitutionally entitled to respect for our relationships as being, at best, facetious, to today, has been stunning. But for supporters of political and socioeconomic equality for people of color, these past few terms have been largely a winter of despair and a season of darkness. In 2013, the Supreme Court struck down a key provision of the Voting Rights Act and tightened scrutiny for race-conscious policies for admissions to higher education. Within days after the voting rights decision, states began to impose restrictive new election laws, including voter ID requirements and redistricting plans that reduce minority voting strength, cutbacks to same-day registration and early voting, and other barriers to full minority participation. Last term, although the Supreme Court backed away from completely barring disparate impact claims under the Fair Housing Act, it hinted at a more restrictive view of what constitutes an impermissible disparate impact. And this term, the court will once again address the question whether race can be taken into account in making admissions decisions at selective universities, and at least 4 justices seem bent on barring it altogether. What accounts for the fact that, to paraphrase Dickens once again, one set of claims seem to be going direct to heaven, while the others seem to be going direct the other way? The actual courtroom at the Supreme Court is surprisingly intimate. Until Chief Justice Burger curved the bench, the arguing counsel stood so close to the justices that he could not actually see them all at once. There are about 400 public seats in the courtroom, and about 100 of those are in the bar section. Now, here's a hint for those of you who are lawyers here or aspiring lawyers. It's really easy to join the Supreme Court bar. All you have to do is be a member of some bar for 3 years, find 2 people who are members of the Supreme Court bar and pay, I think it's $200, and you get a great certificate for your wall. So that accounts for why over 200,000 lawyers belong to the Supreme Court bar. But despite that number, for many arguments, a member of the Supreme Court bar needs show up only a few minutes ahead of time to get a prime seat in the courtroom. But a few times a year, a case garners sufficient interest that not all the bar members who want to come can be accommodated. The oral arguments are then piped into the lawyer's lounge, which, another piece of advice for you, if you can sit in the lawyer's lounge, it's often more fun because you can talk and you can gasp and you can gesticulate, and also you can, although you're not supposed to, you can keep checking your email. But the oral arguments get piped into the lawyer's lounge, which is where the overflow sits. It's the only place in the country with simultaneous audio of Supreme Court arguments, although since October term 2010, the court releases audio tapes each week on Fridays of the week it sits. And the court has even occasionally released the tapes later the day of oral argument. Now, while the tapes or broadcasts can provide valuable opportunities for a broader audience to see the court in action, or more to the point, hear the court in action, they're not a full substitute for actually sitting in the courtroom, any more than a film is a full substitute for a live theater production. Cameras can't really capture the full sweep of the room or the feel of the moment. Certainly not if the cameras are focused solely on the bench or on the oral advocate or on the justice asking a question. So whatever one thinks about the arguments in favor of televising Supreme Court oral arguments are like, there's going to continue to be a demand for seats in the courtroom itself. Now, how should those seats be allocated? There are 4 basic devices for allocating these kinds of resources: markets, merit systems, lotteries, and queues. And as we'll see in a moment, they aren't necessarily entirely separate from each other. They can, in fact, be combined. Each of them has its benefits and its drawbacks. Markets. The Supreme Court could sell tickets to oral argument. After all, spectators buy tickets to many other significant events. And ticket sellers often use pricing models that take into account the demand for a given event. So they could set the price. But fixed price tickets aren't, of course, the only market device for this kind of allocation. There's always the auction. So if the justices know that lawyers are prepared, as they now do, to spend $6,000 to get a seat in the courtroom, the justices could sell tickets at that price, or they could conduct an auction to fill those seats. And if the court were to run this market, it could use the money generated from selling the tickets the same way it uses the bar admissions fees, which is for improvements to the court's common area, for education projects, and for what the court calls museum-like displays for visitors. So if you go to the Supreme Court and you go on the ground floor, all of the displays there are paid for by the bar fees. We could have a merit system. Many scarce resources, for example, colleges and the seats in the entering class here at the College of Law, are handed out not to the highest bidder, or at least never overtly to the highest bidder, but to applicants whom the admissions committee decides will create the best entering class along a variety of dimensions. If we could agree on which lawyers most deserve to see a particular argument, perhaps because of their long-standing interest in it or commitment to the issue, or perhaps just because they've been bar members for very long or the like, the court could create some sort of applications process and award the seats to those attorneys who offer the most compelling reason why they should be able to attend. Lotteries. The United States distributes a number of important public rights and responsibilities through random processes. Perhaps the most well-known current example is the Diversity Immigrant Visa Program, which makes up to 50,000 green cards available annually to eligible individuals chosen at random. The Supreme Court could conduct a lottery from among bar members interested in attending a particular argument. The queue. Many public goods are distributed on a first-come, first-served basis until they run out. The National Park Service, for example, handles online reservations through a system like that, as well as doing it the old-fashioned way at Yosemite Camp 4. So the Supreme Court could simply ask lawyers to line up, either to hand out bar seats at some point prior to the oral argument, or to get in the courtroom directly. Now, scholars have long identified efficiency and fairness as two major criteria for evaluating whether a particular allocation system is good or bad. From the perspective of both the court itself and the lawyers wanting to attend oral arguments, a merit system or a lottery would have significant inefficiencies. While the court could guess at whether there would be excess demands for seats for a particular argument, it's not always going to be certain about that. And conducting an applications process or running a lottery in a case where everybody's going to get in anyway is just going to be a deadweight loss. Moreover, a merit system would require the court to expend staff resources to read and score applications, and it would require lawyers to spend valuable time, otherwise billable hours, for example, writing their applications. A lottery might have less in the way of administrative expenses on both ends, but the court would still have to collect the entries, run the lottery, and notify the winners. And under either regime, the selection would need to be made well before oral argument so the attorneys would know whether to make arrangements to attend or not. Now, whether a particular allocation rule is fair turns on, among other things, the nature of the good or the opportunity that's being distributed. For some goods, the market seems eminently fair. But for others, the idea that the good goes only to the affluent or is allocated on the basis of ability to pay seems deeply objectionable. The Supreme Court itself long ago declared that there can be no equal justice where the kind of trial a man gets depends on the amount of money he has. It might well seem equally offensive to admit people to a building with equal justice over its doorway depending on the amount of money they have to buy a seat in the courtroom. So it's hardly surprising that the Supreme Court's own rule has long provided that the public enters the courtroom by standing on line, and the lawyers enter the courtroom by standing on line. The real question, then, is how that line should operate, and in particular, should the justices, should the court allow people to buy their place in the queue? In What Money Can't Buy, the political philosopher Michael Sandell actually wrote a chapter about the use of paid line standards, and he characterizes it as an example of the growing reach of money in markets into spheres of life once governed by non-market norms. Turning in the queue into a market, he points out, may not even indicate, as markets generally do, an intensity of preference, because in some cases the willingness to stand in line may be a better indicator of who really wants to attend than the willingness to pay. And this is especially true, I think, if there's an ideological objection to paying for the good. Now, Sandell's primary examples of the problem with using paid line standards involve Free Shakespeare in the Park in New York City and paid line standards for congressional hearings. In both cases, he argues, something is lost when an item that is allocated by queue as a free public good is turned into a market commodity, something beyond the disappointment, he says, experienced by those who are priced out of attending. It degrades the nature of admission to the plays or to the hearings to turn them into just another commercial transaction. Now, the argument is a little less straightforward in some ways with respect to the bar line. After all, the bar line is already reserved for relatively affluent elite, and you have to have paid the $200 up front to be eligible to come into the bar line. And I'm not really going to talk about the public line during the lecture itself, although if people have questions about that, we can talk about that during the question-answer session. One of the interesting things is the Supreme Court did not ban paid line standards in the public line in the most recent announcement. But the argument against allowing markets to shape the bar line, I think, still has normative purchase. The process of waiting impresses its own message, a message that the lawyers who Ubered to the court fresh-faced in the daylight didn't have the privilege of receiving. One way to capture this idea that waiting in line has important value in public civic activity is to analogize the bar line to another line in which many Americans stand to participate in the central processes of government, the voting line. Professor Rick Vallely describes voting at a polling place as reminding us that in principle we're all equal members of the political community. On election day, we physically mingle with people who are plainly our equals that day, no matter what other differences we have. This is one of the reasons why he has reservations, for example, about absentee voting or voting by mail, because it privatizes an activity that otherwise sends an important public message to the people who are doing it. The power of this vision of voting was nowhere more dramatically illustrated than in South Africa's first post-apartheid election in 1994, when people waited in line for hours simply to cast a ballot. A white voter who left the polls at mid-morning with his black gardener described the experience this way. Here I've been waiting for 6 hours. Some of these people have been waiting for 30, 40, 50, 60 years. The country has been waiting for 3.5 centuries. Most of us will return to our separate existences tomorrow. In the commotion of the coming days, months, years, much of this day may fade. But there is one thing we cannot ever forget, the knowledge of having been here together, the awareness of a life, a country, a humanity we share. Honestly, I would not trade the hours I spent outside the Supreme Court waiting to attend the marriage arguments for $6,000. Talking to the other lawyers in line and talking to the homeless people who sat with us was an opportunity to discuss the cases we were going to see and to think about them. Now, the Supreme Court's solution to restrict the bar line only to, and I'm going to quote here, only bar members who actually intend to attend oral argument has a particular elegance to it. Not only does it eliminate paid line standards, thereby avoiding the explicit transformation of the queue into a market, but it also eliminates a different form of circumvention and hierarchy, the delegation of line-standing duties to subordinates. As I read the rule, a partner who wishes to attend oral argument cannot direct an associate at the firm to hold her place. Now, my guess is that while lines will form early for a few especially compelling cases, they will not form as early as they did when paid line standards were available. We'll most likely return to the pre-market era, when showing up at dawn got an attorney into the courtroom. The extra 3 or 4 hours of attorney time that will consume is a small price to pay for the equal access it symbolizes. So let me turn now to the question that preoccupied me much of the time I was standing in that line outside the court, thinking about the juxtaposition between the people who are going into the court and the people who are holding their places. Why is it that LGBT equality has made such stunning advances over the past few decades, while racial justice arguments seem to have stalled? To start, let me describe issues in the marriage case on the one hand and the racial justice cases on the other. Section 3 of Doma, the statute that was at issue in the United States against Windsor, and Sections 4 and 5 of the Voting Rights Act, the provisions at the heart of the Shelby County against Holder case, each involved striking assertions of federal power in areas traditionally left to state regulation. Section 3 of Doma created for the first time a federal definition of marriage. With respect to any of the more than 1,100 federal provisions governing issues from who can be buried in national cemeteries to how political candidates can use campaign funds, Doma provided that regardless of whether a couple was legally married under state law, the word marriage didn't apply to them. Sections 4 and 5 of the Voting Rights Act created for the first time a requirement that certain states and political subdivisions, primarily but not exclusively in the South, obtain federal approval before making any changes in their election laws. Both statutes, then, dramatically shifted the pre-existing federal-state allocation of power. Now, if you put that at a high enough level of abstraction, this dramatic shift might have explained judicial skepticism about both statutes. As the Chief Justice reminded us in the Affordable Care Act cases, while legislative novelty is not necessarily fatal, and there's a first time for everything, sometimes the most telling indication of a severe constitutional problem is the lack of historical precedent for Congress's actions. But it's important to keep history in mind. The Voting Rights Act came at the end of a century of failures to realize the promises of the 14th and 15th Amendments. Finally, Congress took its responsibility to enforce those amendments, a responsibility quite deliberately enshrined in the text of the Constitution as being Congress's, seriously. And Congress's decision to extend and amend the 1965 Act came after dozens of hearings and was based on thousands of pages of record evidence. By contrast, Doma was passed as a knee-jerk reaction in 1996 to the possibility that states would provide legal recognition to same-sex couples. Now, this is the signing of the Voting Rights Act. You'll notice there are a lot of people there. It's a very big deal. This was the signing of Doma. There was no signing ceremony. It was signed at midnight, and the president issued this little tiny thing in little tiny print, which they always tell you not to put on PowerPoint slides, but the whole point of this is there's just little tiny print and nothing else. The design and the purpose of Doma were to undercut state authority, not in the service of pursuing equality, but in the service of cementing inequalities into place. So it was particularly striking how the court used ideals of equality in the two cases. In Windsor, and later in Obergefell, and this is Edie Windsor and Jim Obergefell, the use of dignity and equality was pretty straightforward. New York and state and Ohio and were denying people dignity under the law when they couldn't give them the full benefits of marriage. And one of the notable aspects of Justice Kennedy's opinion for the court was how often, instead of using the word equality, he used the word dignity, a word that appears nowhere in the constitutional text to describe the value at stake. In Shelby County, by contrast, Chief Justice Roberts' opinion for the court talked a lot about equality and dignity, but not about the political equality and dignity of the Black, Latino, and Native American citizens who were protected by the Voting Rights Act, but rather about the constitutional equality, as he called it, and the dignity of the states. By treating states differently, the Voting Rights Act undercut this equality. So let me just make one point about history and interpretive method. The Chief Justice's opinion focused on the framing in the 10th Amendment, but it ignored entirely the historical context out of which the 14th and 15th Amendments emerged. The Constitution we have today is not the Constitution of 1789. Even as a pure matter of language, the Constitution's text today embodies the commitments of the 13th, 14th, and 15th Amendments to racial equality, the commitment of the 19th Amendment to gender equality, and the commitments of those amendments plus the 17th, 23rd, 24th, and 26th to broader political equality. Both the marriage cases and Shelby County are, in a fundamental sense, cases about how constitutional principles interact with social conditions. At the oral argument in Hollingsworth against Perry, the case involving the challenge to California's marriage restriction, Justice Scalia demanded that the challenger's counsel, Ted Olson, answer the question, when did it become unconstitutional to exclude homosexual couples from marriage? 1791? 1868, when the 14th Amendment was adopted? Ted Olson ultimately suggested it became unconstitutional when we as a culture determined that sexual orientation is a characteristic of individuals that shouldn't trigger legal disabilities, to which Justice Scalia responded, I see. When did that happen? When did that happen? And when Ted Olson replied, there's no specific date and time, this is an evolutionary cycle, Justice Scalia shot back, well, how am I supposed to know how to decide a case then if you can't give me a date when the Constitution changes? Everybody's looking for dates. In one sense, there was a clear-cut answer to that question in Windsor, and I think in Obergefell. It was unconstitutional in 1996 when Congress enacted Doma for the federal government to strip legally married couples of the benefits of marriage simply because they were gay. And it was unconstitutional in the years following Doma for states to restrict marriage only to opposite-sex couples, enshrining that exclusion in law and offering no better justification than the fact that gay people are less irresponsible than straight people, and therefore they don't deserve the benefits of marriage, because the whole point of marriage is to rein in feckless, reckless, seed-spreading straight men who otherwise can't be relied on to take care of their children. It was one of those wonderful moments. If you've read 1984, the book, you'll remember during the 2 minutes hate, they're all sitting there staring at the screen, and the screen says something like, you know, we're at war with East Asia, we're at war with East Asia, and everybody's screaming, we hate East Asia, we hate East Asia. And then all of a sudden in the middle it flipped and they're at war with Eurasia, and it's now, we hate Eurasia, we hate Eurasia, we hate Eurasia. The arguments for denying gay people the right to get married until about the year 2005 were always gay people are immoral and don't deserve marriage. Marriage is reserved for the kind of sexuality that we consider to be moral. And then, like on a dime, people switched and started arguing, no, the whole point of marriage is to deal with irresponsible procreation, and since only straight people can procreate irresponsibly, they're the only ones who really need marriage. Makes you really want to get married once you find out that's why they allow it. But as a matter of realism, whatever the actual answer to that question, that answer doesn't wash, because in 1996, it's impossible to believe that the court would have struck down Doma. Indeed, in 2013, it seemed really clear in the courtroom when you looked at Justice Kennedy's unhappy face when he said, can't we just get rid of this case during the oral argument in Perry, that the court was not yet ready to hold for marriage equality nationwide. But times changed. As Justice Kennedy explained in Lawrence against Texas, the framers and ratifiers of the due process clauses of the 5th and 14th Amendments knew times can blind us to certain truths, and later generations can see that laws once thought necessary and proper serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. Now, Justice Scalia and the conservative majority had no trouble recognizing constitutional change in Shelby County, of course. There, Chief Justice Roberts' opinion for the court held that although the Voting Rights Act had been constitutionally appropriate as a response to the world of the 1960s, nearly 50 years later, things have changed dramatically. It's the Edmund Pettus Bridge in 1965 and the Edmund Pettus Bridge in 2015 with the President's March over the bridge. That change in the world, according to the majority, changed the strictures of the Constitution. So too, when it comes to race-conscious affirmative action, the court has shown itself reluctant to permit its continued use 50 years on from the Second Reconstruction. So the real question, it seems to me, is how to understand how the world has changed and how those changes should inform constitutional interpretation. And here, it seems to me, is where the world outside the courts has affected the decisions inside them. The LGBT equality movement has succeeded because it has managed to gain widespread support from outside the gay community. It has managed to convince people of goodwill from across the political spectrum that homophobia exists, that it's wrong, and that constitutional law must respond to gay people's claims for full inclusion in the key institutions of civic life. It is, I think, the most successful civil rights movement of the last quarter century. By contrast, the civil rights movement, which once was precisely such a movement, searing the nation's conscience with the March from Selma to Montgomery, whose 50th anniversary we celebrated this past spring, has been far less successful in recent years in building a broad popular consensus in favor of civil rights. Perhaps this is because the LGBT movement today is still dealing with formal exclusion, and so the issues seem far clearer. Moreover, these first-generation problems seem particularly amenable to purely legal solutions. While those formal, de jure exclusions, by contrast, are not today the major barriers that exclude people of color from central institutions of civic or economic life. Rather, the interaction of what look like facially neutral rules with socioeconomic disparities is the central issue facing minority citizens. That's why, for example, disparate impact theory is so important a part of the racial justice arguments at the Supreme Court, while it plays virtually no role at all in cases involving LGBT plaintiffs. That's a picture I took in Selma when I was down there for the 50th anniversary of the March on the Right, and you'll see Selma doesn't look much better today. It's still dirt poor. It has finally started to elect representatives who are representative of the community as a whole. But it's not as if the civil rights movement brought a new day and new era to Selma. Now, a second major difference between the movement for LGBT equality and the movement for racial equality involves an offshoot of the point Professor Bruce Ackerman made in his foundational article, Beyond Caroline Products. There, he challenged the idea that discrete and insular minorities, to use footnote 4's famous formulation, were especially disadvantaged in the political process. Being discrete and insular, he suggested, might make it easier for a numerical minority to organize and to press its demands. By contrast, being invisible and being diffuse might make it harder to do so. Now, Professor Ackerman was writing in 1985, so right around the time that Bowers against Hardwick was going to the Supreme Court. So his suggestion that the victims of sexual orientation discrimination, rather than racial minorities, will increasingly constitute the groups with the greatest claim upon Caroline's concern with the fairness of the pluralist process, made perfect sense back then. This I just love. That's filled milk on the right. That's the thing that was actually at issue in Caroline Products. And that's a rainbow of milks on the left side, reminiscent of Justice Ginsburg's wonderful question at the oral argument in Windsor about whether Doma created skim milk marriages for gay people and whole milk marriages for straight people. And you also have to wonder, like, which people's marriages were yogurt, and with the yogurt ones, which had the fruit in them and which one had the fruit on the bottom. It was a sort of odd metaphor, but very powerful. But here's the thing. 30 years after Professor Ackerman's article, gays are no longer invisible. And in two central ways, they're not insular either. The vast majority of gay children are born to straight parents. As a result, whatever discrimination gay people suffer in one particular generation is not visited directly onto gay children as they start their lives. And many straight people have direct connection to gay relatives or gay friends or gay colleagues at work. By contrast, intergenerational wealth effects continue to influence minority children's life chances. Middle-class black families, for example, may have similar incomes to white families, but their net wealth is only a fraction of those of their white counterparts. And this slide is incredibly telling because what this slide does is it looks at, for any given level of income, what is the relative wealth of black families with that income and white families. And does this have one of the points? Well, here, I won't run right up there. But what this basically shows you is that for black families that are in the 90th to 100th percentile, that means black families that are doing very well in this country, they have about 40%, somewhere around 35 or 40% of the wealth of white families in that same group, because they didn't start life with the same economic advantages. And the result of this is that there is a huge wealth gap in the United States that affects the life chances of children because it determines where their parents can buy a house, whether their parents can pay for all sorts of things that will make them attractive applicants when they apply to colleges, tutoring and the like. Persistent racial segregation in residential areas means as well that many whites have little direct exposure to people of color. In a 1999 study on race relations within law schools, for example, 50% of white law students reported having had no or very little interracial contact while growing up. The upshot is that residential and educational patterns and income inequality make it unlikely that the powerful feel quite the kind of direct connection to the disempowered that the straight often feel to the gay. A line I like to use a lot is, no conservative ever wakes up to discover that his son is black or poor or undocumented. And it was stunning how many people who had opposed marriage equality all of a sudden came around when they discovered that if they wanted to be walking their child down the aisle, they were going to have to change their views. So that's really, in a nutshell, I think what the differences are. The Supreme Court of today, like the court at the end of the first Reconstruction, seems to think that there must be some stage in the progress of the black citizen's elevation when he takes the rank of a mere citizen and ceases to be a special favorite of the laws, and when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected. Those words are from 1883, but they capture perfectly the attitude of a majority of the Supreme Court today. Indeed, in some ways today may be even worse than 1883 about this attitude, at least, in that the Voting Rights Act and the affirmative action policies of public universities were adopted by the ordinary modes by which other people's rights are protected, and yet the Supreme Court strikes them down. The juxtaposition of claims of gay equality and racial justice that struck me as I stood in line last April came back to me with special force on June 26, 2015. That day, the Supreme Court held in favor of marriage equality, and the White House took on the rainbow colors of the gay pride movement. And it was one of the real thrills of my life that I actually just fortuitously happened to be over at the White House while this was happening. And it was tremendously moving as you watched it get darker and darker, and the lights came on with these gels from underneath the White House. But June 26th was not just the day of the White House turning purple. It was also the day that President Obama went to Charleston, South Carolina, to speak at the funerals of the 9 Americans who were murdered as they prayed at Emmanuel AME Church, also a purple day. Just as even in dark moments there must be hope, so too in moments of triumph there is often sorrow as well. Et in Arcadia ego, and even in Arcadia, I, death, am there. Thank you very much. So there's a little time for questions if people have questions or anything. Yes, sir.
I loved your talk. Thank you so much. I wanted to address 2 things.
Yeah.
One is, you said, when did it become unconstitutional to bar same-sex marriage?
Yeah.
And your account, I think it goes back to Doma. What I wanted to suggest is I think there's also been a fundamental series of shifts in the institution of marriage itself, something that Justice Roberts, of course, denies by thinking that there's a static conception of marriage that's been existing for all of humanity completely incorrectly. But in the United States, what has been happening is we went from a conception of marriage that really did look like it was a form of control through religious organizations and communal organizations as to how procreation is exhibited. And so we would see things like less laws for statutory rape within a marriage, laws against procreation, a division between parental support for people born inside and outside of marriage. This goes to your race issue, restrictions on interracial marriages in 40 states between 1840 and 1967. What that means is that every person born of mixed heritage is going to be a bastard and is not going to get the same property and other rights, which is going to kind of promote some of these other things and so forth. And the movement has been away from a lot of those things and more towards conception of consensual marriage in various forms. My sense is that there's nothing really that new at all about Obergefell. At a certain point, marriage evolved. It's now an institution about consent between 2 persons, and now we have the equal protection question as to whether it is consistent with the Equal Protection Clause to allow some, but not all Americans, to marry partners of their choice. So it's a slow evolution, but I just wanted to offer that alternative account of when it became a constitutional question that doesn't make it so new and unprecedented. The other thing I wanted to say is on the point of why there's this asymmetry. I do think segregation is the biggest problem. So you have people who have very strong and good moral arguments on both sides, but then you have the question as to who they're able to convince. And when you have these cycles of poverty and segregation that have been continuing, and I've really profited from Elizabeth Anderson's book, The Imperative of Integration, what you end up getting is you end up getting people who are speaking past each other and don't trust each other and don't have the ability to change each other's views. You're absolutely right that a gay child can, talk to a parent and something can happen, but I think that that's very, very difficult when people are having very different experiences. There's a whole lack of trust, and then they're not speaking with each other. And I think the really fundamental problem we have in our culture, if we want to get to equal justice, is to figure out how to overcome that and have real interfaith dialogue, inter-race dialogue, and so on. So I'm just elaborating on those points, but what do you think about those 2?
So on the second point, first about racial segregation, absolutely. You know, there's also been some interesting work. Cindy Estlund wrote a book about democracy at work because it's often the only place that people from different races interact at all. That is, they live in separate communities, they go to separate churches. And so I think fundamentally you're absolutely right. And my basic takeaway from this is it's much easier to convince people about something where they have some intuition about the person who's trying to convince them. And that's become harder. For those of you who read the New York Times, I think it was, I can never tell when you read it online, it was either last night's story or today's story about the University of Missouri pointed out that almost the entire black population of Missouri is either in Kansas City or St. Louis. And so the kids who are coming from those school systems have been in racially integrated schools at least somewhat at some point in their lives. But the rest of the kids coming from the rural parts of the state, it's their first experience. And no surprise that a lot of tensions arise out of that. On your first point, it's a really interesting one, and the historians' briefs in the marriage cases tried to make exactly that argument, which is once marriage ceases to be a gendered institution in the way that it was at the time of, for example, coverture, where women were subsumed entirely as legal entities into their husbands, the gender roles in marriage then became more a question of people's individual choice and not a question of law. And I remember at the oral argument in Obergefell, there was a moment early on where Justice Alito said, well, you know, I've looked at marriage back to the time of the ancient Greeks and the Phoenicians, and there's never been same-sex marriage. And if they didn't and the ancient Greeks didn't have a problem with homosexuality, but they banned they didn't have same-sex marriage. So what do you have to say to that? And my answer to that would have been the following. The whole point of marriage for the ancient Greeks was control of women's fertility so that men would not have to raise other men's children. Taking that as an argument for marriage today when the argument is men should have to raise their own children seems completely beside the point. And so, you know, the Greeks did a lot of things we don't like. They also had infanticide. They had slavery, so using their model of social organization, not so good. I do think there are two evolutions, right? One is the evolution of marriage, and the other is the evolution of attitudes towards adult sexual activity. And those two things, in some sense, intersect when you get to the marriage cases. But I agree with you that it was not that it became unconstitutional in 1996. It's just that that's when Doma was passed, and so I started with that as the starting point for when Doma was unconstitutional. Yes.
I want to thank you for the talk, obviously, and particularly for the really brilliant juxtaposition of the Barline story and this difference that we're seeing in these two areas of law. And I want to kind of go back to maybe another possibility as to what some of the similarities there might be. And I think about the Barline story is really a story, as you pointed out, about the distribution of a limited number of goods, and then the use of markets or other sorts of systems to distribute those things. I think that the sort of same-sex story is very different from the sort of racial equality story, and in some ways, because of that difference that we're seeing in the Barline story. So, for example, if there were a limited number of marriage licenses, maybe it would look very different. If there were only some set number, then it might not be as successful, the sort of the marriage equality story as we've seen, because that's not a good that really impacts. There's not a zero-sum game there in the same way. Whereas I think that with the old sort of civil rights equality story, you know, allowing everyone to sit in the same place or attend a certain, you know, sit in the same restaurant, doesn't also have the same zero-sum feel as what I think is happening today, which clearly is race-based, but also has an economic, sort of the other point that you made about the distribution of wealth and so forth, which is different and in some ways more similar to the Barline story. And I want to go back to the Barline piece because I think that one of the similarities or one of the issues there is the difficulty in coming up with a solution, right? So the Barline, the way that was resolved isn't a perfect solution in some ways, right? It solves some of the dignity part of what you described, but not necessarily the equality part of what you described. And I'm curious about the reaction of the people who now can no longer earn whatever it was they were earning. I'm also interested, I thought it was also interesting that when it felt like this might be poor college kids sitting out there, it didn't feel the same as when it turned out to be sort of middle-class, poor blacks who were sitting out there. And when you mentioned that, hey, I wouldn't do this, I wouldn't take $6,000 instead of that experience, but for some people, that would be, a tremendous sort of benefit. So I think that all of those things sort of put together for me the difficulty of solving the Barline story in a way that responds to the concerns of the people who actually were earning a living that way, which is sad and disturbing to a lot of us. But it also goes back to the earlier question about the racial equality. So I wanted to just get your comments about that, and really thank you for the juxtaposition, which will give me a lot to think about over the next few weeks or years.
Well, thank you. That's a fantastic comment, and I definitely want to, the first point about the zero-sumness versus non-zero-sumness, I think is spot on. I mean, you're absolutely right about that. One of the additional complexities is the interesting way in which marriage was turned into not a zero-sum game, because there were arguments made throughout the lower courts that I wrote an article a couple of years ago called Constitutional as Trademark, and I talked about marriage as a trademark that a lot of people claim was being diluted. That is, you will dilute the value of my marriage if you let these people, whoever they are, get married. And one of the real triumphs of the marriage equality movement was to somehow get that argument off the table so that nobody was still making it by the time the Supreme Court made its decision. That is, no one was claiming, my marriage has been devalued because you've let these terrible people get married, and now who wants to be married anymore? So that's the first point, and I will definitely add a discussion of that to the paper as I go along. The second question, the question about arguments about if there's a market that you think is deeply immoral, what do we do about the people who are earning their livings in that market, is such a rich and complicated question. You're absolutely right. Sandell talks about it a little bit with the line standers, but it also affects things like arguments about prostitution, about low wage, all sorts of low wage work in other countries. And I don't know how exactly to answer that, except to say that it doesn't seem to me that the solution, if you think that a particular earning a living in a particular way is a deeply bad thing because of the messages it creates, it doesn't seem to me that the solution is to say, well, allow people to keep earning their living that way, as opposed to recognizing that you have to come up with some other way for people to earn a living that doesn't require them to do something that we don't think should be a market good at all, whatever that good is. And we can have arguments about whether, working in, factories in other countries are that, is it wrong to refuse to buy stuff made by child labor? It's a hard question for some people, because they say, well, if you didn't buy the stuff, then the children will starve. On the other hand, if you buy the stuff, you're complicit in a decision to have children work when they shouldn't be, when children that age really oughtn't to have to be working in factories and the like. So that's a really hard issue. I just know there are things I wouldn't pay for. And I guess maybe I was selfishly happy that the Barline was changed, because there was something, for me, so striking about the fact that it was for arguments about equality that people were doing this, that, maybe I wouldn't have felt the same way if it had been watching lobbyists do this for the Affordable Care Act cases. But at least when I showed up, I just felt sick. And the thing I vowed to do, and then I didn't do it because I was cold and I was tired and I wasn't very well organized, and the like, was I wanted to take a picture from exactly the same place every hour from 2 p.m. until the Barline the next day, and I just didn't do it to show what the Barline looked like. But I take that point, because it's one that comes up almost always when you deal with banning a market in something, is what do you do for the people who had been selling services or goods in the market beforehand.
I think we're out of time. I wish we had more, but
there's food.
There's food. I think Margaret's exactly right. I mean, Pam has given us so much to think about in the coming days and months, and I hope that just as she is the first person to have given 2 endowed lectures here, that perhaps we can convince her to be the first person to have given 3 at some point. So maybe let me give you this little token.